So thank you everybody for being here tonight. I'm Lisa Nee. I'm with the small but mighty League of Women Voters of the East Shore. This is our second constitutional event in the series. Our first constitutional event was on September 17th, which is Constitutional Day. And we had high school students from all up and down the shoreline read the Constitution out loud, and Senator Christine Cohen was there as well. What was really exciting about that, I guess one of my favorite parts, is when we all got up and read the preamble together, and to hear those young voices in harmony with some of our older voices was really, really invigorating. The hardest part was that when you read the Constitution, you have to wait for some of those amendments. And waiting, especially for the 19th Amendment, and, the 19th Amendment, women to vote, and the 13th Amendment, that's pretty hard to wait to do, but you know it's coming, so thank goodness. So Connecticut is like the pizza capital, the nutmeg state, but on your license plate, most of our license plates say it's the Constitution state. And it became that because it refers to the Connecticut's adoption of the fundamental orders in 1638. And many consider the fundamental orders the first written constitution to establish representative government. So, yo, Connecticut. So what do we say? And this is what you can bring to the streets the next time you're out there. You go, we don't bend, we don't break, we're the Constitution state. All right, so let's try it. We don't bend, we don't break, we're the Constitution state. Yes, I love that. So there's another person here who doesn't bend or break, and that is Sujata Gadkar Wilcox, or as many of us refer to her, SGW. She is a senator proudly serving the 22nd District, which includes Bridgeport, Trumbull, and Monroe. She's chair of Special Education, Government Oversight and Regulation and Review Committee, okay, Pew. She's vice chair of the Higher Education and Employment Advancement and Judiciary Committees, member of the Education, General Law, and Transportation Committees, professor of Legal Studies at Quinnipiac University, a Fulbright Nehru Scholar. She has a BA from Cornell, she has an MA from the New School, and her law degree is from the University of Pennsylvania. And now, we also know we had her first, she's a League of Women Voter member, but this is her first time doing this presentation in Madison, and she's going to add that to her honor roll. So, here we go, SDW, take it away.
Thank you so much. Hi, everyone. Good evening. Thank you so much for being here. Can everyone hear me? Is that okay? Okay, good. And thank you so much to Lisa for putting this together to the League of Women Voters. I am a proud member of the League of Women Voters, and this is what I care about most. And I should say I just got elected to the Senate, so this has been my first session. It's only been a couple of months, but it feels like a couple of years already, given all the things that we're trying to address. But I have been teaching this document here that you have with you, the Constitution, for a lot longer than that, for more than a decade, since I started teaching at Quinnipiac in 2011. I love this document. And, you know, one of my problems with us, when I now put my us as academics hat on, is that we do so many wonderful programs on campus, and nobody comes, even our students. We have to like beg them to show up to programs on campus. And the problem for me is this is our document collectively. It belongs to the community. It belongs to the people. And so part of why I do this, you know, and one thing in the Senate, because I'm a new senator, you know, is you're doing all these events outside of your district. You have to be in your district, and I'm in my district plenty. But this is my commitment to democracy. We have to do these events because I want people to ask questions about the Constitution and have some framework for those who are not familiar. And sometimes we have constitutional experts in the audience too. But so that we can engage in a discussion about some of the things, historically, that have been put in place to balance power in a way that is being disturbed right now. And so what can we do? That's the ultimate, the very last slide, I think there's a picture, in fact, of the League of Women Voters as part of that, is this. What we can do about it is show up, talk about the Constitution, use the language of the Constitution, and sort of challenge the limitations and the restrictions on the Constitution when it's being challenged, and to use our voice collectively. So that's why that's so important to me. And one of the things I should say, I've been teaching this document even longer than I've been involved in politics, and one of the problems for me now is everything gets put under a partisan lens, and that's really, really a problem, because I think we should be able to have not partisan debates, but we should be able to have policy debates that parties have different perspectives on that. That's fine, and let's debate those things. But let's separate them out from things that we have to stand up for collectively that are not partisan, that are not even sort of based in party differences. And that's where I see some of the constitutional infringements, when it comes to, for example, due process restrictions before deportations. That's not really a debate. If you want to have a debate on immigration and say what's the pathway to citizenship, how many people should be deported, what's the process, that is something that maybe is a policy debate, and we'll talk about that also lies with the federal government. But when you are depriving people of due process rights or interrupting due process proceedings, to me that's not partisan, and it's okay for us to say that. And it shouldn't be a party-affiliated position. It should just be this is where we have to draw the line for some of the constitutional debates. So that's and by the way, there are debates. So we have debates in class. I teach every semester. I teach constitutional law. Tomorrow I'll be back in class talking about the First Amendment, and we do have debates because there are in fact constitutional debates about how we interpret the document. But that's different than the debates that we're having now. So I hope to sort of, at least give you some information on what that balance of power looked like, what the framers envisioned, talk about some of the issues we're seeing today. And happy to I would love this to be really not a class in constitutional law, but a conversation. So if there are questions that come up along the way and you want to ask, we can do that. I want to leave plenty of time for questions, because the whole point, I've been doing these talks, like I said, in different parts of Connecticut, maybe like a dozen times now, and they've just been electric because people have been asking questions, and that's really the point for me. So I'll start with some kind of foundational information, and then as questions kind of arise, please feel free to ask them. I know there are note cards, so we can see how it works. We'll just kind of go with what works best. So let me start with this slide to talk about our constitutional democratic republic. You may have been hearing, I've been hearing a lot in social media debates in particular, we're not a democracy, we're a republic. And I'm a little confused, actually, like why this is such a big, I was looking up a little, like why is this a narrative that people are telling? The reality is that we're both. We are a democratic constitutional republic, or a constitutional democratic republic, however you want to put that. And when people say we're not a democracy, that's a little misleading, because we're not a democracy in the Greek sense, yes. So we don't have everyone doesn't have direct access to vote on laws and to deliberate on the process, but we are in fact a representative democracy. And the reason that the democracy piece is so important, that you're all here, right, for grassroots engagement, is because going back to sort of the foundations of the Constitution, the theory, the legitimacy of the Constitution comes from the consent of the governed. So the consent of the people. So the more you're encroaching on the consent of the people, you're now starting to challenge the kind of democratic aspect of the Constitution, and that's important. And we see that. Do we see that in a contemporary sense? Yes. Well, you see that, for example, when you see gerrymandered districts. Gerrymandered districts are districts that are shaped around particular interests, and what that means is those interests are overrepresented, and other interests that are actually more demographically, resonant in that community are not being heard. So that is, in fact, not real. That's violating this sort of fundamental theory of democracy, because it's not really one person, one vote. Your voice isn't, in fact, equal in a district that isn't a fair district. And that's why that's important. When we just allow unlimited funding to go into public campaigns, that's starting to violate, right, this principle of democracy, because that can't be about the consent of the people. That is a very narrow special interest. And even though the court, long before Citizens United, said, look, corporations, for tax purposes, corporations were considered individuals, fine. There's still a difference between a corporate individual and a person individual. There's a difference in your influence, there's a difference in your scope. So even if you want to call a corporation an individual, which we do for other administrative purposes, the court's sort of taking that the next step to say that voice is equal to the voice of the individual. And so therefore, campaign financing, when it comes from corporations, is also protected under the free speech of the First Amendment. We can talk about that a little bit more, but the court has said that that's protected under the First Amendment. That now starts to violate this idea of democratic legitimacy, because that's not the people speaking, right? Now you have over-representation of narrow specialized interests. So those are the kinds of things that we have to think about. Whether there's a provision in the Constitution or not, we still have sort of a spirit of the document, a purpose for the document, and the democratic legitimacy is one. So we're also a republic, importantly, because we have institutions that check sometimes the majority, right? So if 90% of people, for example, wanted to eliminate the right to free speech, you wouldn't be able to do that. We wouldn't be able to do that, hopefully, because the court would step in and say no. We have institutions like the court that says, look, well, we have a framework in place, the Constitution, that says you can't just do whatever the majority wants because there are some foundational ground rules. And that's why it's a democratic republic. So it's about, and above everything, of course, is this document, the Constitution, that sets sort of the framework for government. Okay, so that's our government. And then interestingly, the most important thing is we have a parallel system of government. So here's another trivia question that's not on there. How many constitutions do we have? How many constitutions do we have?
51.
Yes, at least, right? Depending on the territories. But we have one federal constitution. So the document you're holding, or that we handed out, and the one that I'm holding here, is our U.S. Constitution. So the United States Constitution is our federal constitution. And when this constitution refers to the United States, it means the federal government. So when you look at this document and it refers to the states, it actually interchanges the states and the people. And the federal government, the U.S. government, is referred to as the United States. And we'll talk about that too. We're like, what's the balance? Because there have been some challenges between, where is the state's authority and where is federal authority, and how has that been challenged? So if you look at the state and federal authority, we're going to look at this together. But Article 1, Section 8. So first, does anyone know what the first 3 articles in this Constitution are? Most people jump to the Bill of Rights, which are the first 10 amendments of the Constitution. But the articles are really important, and people tend to skip over that or not know as much about it. But what are the first 3 articles to the Constitution? Our branches of government, yeah, so separation of powers. So we have the functions of government, and number 1 is always the legislative branch. And going back to that democratic legitimacy, number 1 is always the legislative branch because it's the most representative. And we come from a history in the UK of parliamentary supremacy, which means there is no court that tells the parliament to go and correct itself. Parliament corrects itself, and that's another way to function. You don't have to have a court step in. We long debate this issue of judicial review, of where the court can step in and say something is unconstitutional and override Congress and override the state legislatures, and we kind of accept that. That's been debated, by the way, and still continues to be debated. It's part of our history now, but that's not the only way to govern. There are other systems where you can just have the parliament check itself, and you don't have rampant rights violations like in the UK. But that's not our. We do have Article 3, which is a court that does check Article 1, but Article 1 is, we have the legislature, which is the most representative, then the executive, right, which is probably the shortest. Both Articles 2 and 3 are shorter than Article 1. So we're going to look at Article 1 because the scope of federal power, despite what people think, is actually the one that's limited. People think it's the federal government that can just do whatever they want. And my students often think, and the one thing I tell them in class is, I hope you take this back to your communities, the federal government is not over the state governments. It's parallel to the state governments. And it has certain functions, and those functions are identified in Article 1, Section 8. And there's a reason we need a federal government, and there's a reason it serves those functions, but it doesn't supersede the state governments, which are in the 10th Amendment, which we'll look at together too, which have actually reserve powers. So we have a balance of power, with the balance actually being with the states. And so when there's a tension and that conflict there, which we've seen particularly in today's, like in the last couple of months, it's been around immigration. And why do I say that? It's been around immigration because we have federal aid officers that are coming into the state, which, by the way, they have been doing. Deportation is not new. So federal officers have been coming into states to carry out deportations. These are federal investigations. The question is, can they ignore state protocols when they're doing that? The manner in which people are being deported, especially in the last couple of months, is what's different than the deportations under other administrations, whether they were Democratic or Republican. Because you have, in fact, a couple of months ago, you had a direct, ICE agents, one, wearing masks, right? That was never the case before, but you wearing masks, not identifying themselves, and then also ignoring, in some, like in Stanford, in Hamden, in Danbury, ignoring the authority of the state judicial marshal when they were asked to show identification. So now you're violating state protocol in trying to conduct that federal investigation. That becomes a federalism question. That becomes a constitutional question. Not just, are we happy with the, is this about which president? No. This becomes a constitutional question. Who gets to say which protocol has to be followed, right? And the 10th Amendment will tell us it's the state. The state protocol has to be followed, right, before you can continue to, conduct your federal investigation. Okay. So that's so we're going to come to that. I just want to start, and as Lisa said, I just think every word in this document is so powerful. So I don't know if there's somebody that wants to read it, or if we want to all read it together. Together? All right. Maybe we can read this together. If I can see my document now with the light, now I have to put it a little further back. Oh, okay. So yeah. No, we're good. No, the lights are good. I can put it. It's my eyes, not the light. I have to put it a little further back. Okay, should we read it together? All right, because these words are so powerful. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Okay, every time I hear those words, I find them moving. So let's start with, when we talk about democracy and democratic legitimacy, the three most important words in the Constitution: we the people, right? We the people. And that signals to you it should always signal that when that consent is being challenged, and in two very critical ways, and this has been for the last decade, right? Gerrymandering and public finance, for example, restrictions on public finance reform, that we're now challenging the kind of consent that goes into the document. What does it mean in order to form a more perfect union?
It can always be improved.
Yes. Great. So one thing, right, is we're not sure what the balance is, and we know that for sure. The one thing that I think is the wisest thing that you can do if you're ever creating something is to leave room for error, right? And it's nice that the framers had enough humility to say leave room for error. And anyone know, how did they leave room for error in the document, in the Constitution? Amendments. Now, we can debate whether or not they actually left room, or the Constitution can be amended because we have so few amendments. But there is Article 5. So we do have an amendment process that says, look, in case we made a mistake, It's there. It's actually also in the Bill of Rights, because one of the reasons the Bill of Rights is not part of the original Constitution is because some of the framers were really worried when you write something down, you create a list, what happens if you leave something off the list? It gets considered irrelevant, right? So it's no longer a fundamental right, or won't be considered a fundamental right. So even to correct for that, right, they included the 9th Amendment, which says that rights not enumerated in the Constitution are still reserved to the people. But even with the 9th Amendment, it turns out very, very difficult to get a right that you cannot hook into one of the other amendments of the Constitution. So if we ever want to think, for example, about like the right to the environment, the right to the internet, the UN said is the next fundamental right, it's very difficult in the US to kind of get that grounded in a constitutional hook. I mean, if you look at the right to privacy, for example, and the right to abortion is just part of the right to privacy, but that is the most explicit, implicit right you could have in the Constitution besides the 9th Amendment. You have it specifically kind of in the shadows of other amendments in the Constitution, and even that the court said, we don't know, right? There's a question mark on it. So if we can't get some certainty around the most explicit, implicit right that's there, I'm not sure how we can add new rights, even though the framers kept that in. But they did leave room to continue to establish a more perfect union in order to kind of balance that out. And in particular, the real balance was always between how much power goes to the federal government and to the states. That's sort of been the long-time platform or even differentiation, if you will, between the parties, Federalists and the anti-Federalists, right? How much centralized power? Today, it doesn't really track because most parties are somewhere in the middle, and in fact, today you probably find the parties saying the opposite of what historically that party would say. For example, you see the Republican Party saying a lot of supporting expanding not only the executive, the federal executive, which is not the states' rights party, right? And then you have the Democrats saying, wait, we have states' rights, we have the 10th Amendment. So it's kind of flipped around. And that's why I say these debates have nothing to do necessarily with party debates. We should be focusing on the constitutional debate. But there is a debate as to, well, how much power goes to the federal government? How much power should we have to the states? And then I just wanted to point out one thing here that's important. So here we see after promoting the common defense, promoting the general welfare, and then securing the blessings of liberty. So we tend to have a narrative only around rights as liberties, that we can do anything we want with sort of absolute rights, but there is no absolute right in the Constitution. And those rights have always, always, always been balanced with the general welfare. So speech, for example, if you're saying something and it's threatening, that's always been able to be restricted, even though the First Amendment says Congress shall pass no law abridging the freedom of speech. Even though it says Congress shall pass no law, that just means the bar is very high. So we have very few exceptions for speech. But do we have exceptions for speech? Yes, because when the general welfare is being threatened, we have to balance that. Now, the standard is very high, and so we have to balance that. But one of the issues that had come up earlier, and not that we want to go back to the pandemic era, but the question of is the requirement to wear a mask, is that constitutional? And I would say the answer depends, especially initially, would depend on what the science said, right? Because wearing of a mask, is that a deprivation of liberty? Yes, it's a slight deprivation of liberty. And nobody wanted to do it, probably. It's not very comfortable. But if that was the only thing, as the science initially said, would sort of stop the pandemic and the kind of devastation that was sort of coming from the pandemic, right, at least in the beginning, then it was probably, the constitutional balance would probably be in favor of constitutionality for that kind of requirement. Now, as the science changed, then probably no, right? As the science changed and we have vaccines and there's no need for a mask, then a state mandate to say, well, you have to wear a mask anyway, well, now that would probably be an unconstitutional deprivation because there's no need for it. So there's always this kind of balance between the general welfare and individual liberties. And I try to make sure my students sort of understand that too, so that people don't go and say, no, everything we're focused on is this narrative around liberties, but there's always been this kind of balance, and right from the beginning of the Constitution. So that's really important. And then just that these principles are for ourselves and our posterity, which means they're supposed to be long-lasting. All right, and I want to point out my favorite provision of the Constitution that hardly anybody ever talks about, but I think it's the most important thing the framers did, and it gives you a real sense of the kind of spirit of the Constitution. And that's in Article 1, Section 9, no titles of nobility, right? That they've ended titles of nobility. That's huge. And why is that huge? Because we actually have places where there are still titles of nobility, like the UK. And despite what people say, that's not just symbolic power, that's real power. That's real economic power, and that's real political power. And that title means that that land that you've taken as part of that title can now be passed down to your family, which means it's out of the hands of the public. It can never go to anybody else. It's not part of the commons, it's not part of the public. So that's real economic power when you allow people to hold on to those kinds of titles. And I think the most radical thing, in fact, the framers did was to say, no, absolutely not. You serve the office. I think that's amazing. You serve the office and then you leave. You know, you're a teacher, you go back to teaching. You're a farmer, you go back to farming. You're in business, that's what you do. And you are there for the time that you serve the office. And we're losing that kind of idea of what it means to serve, right? To serve now, it's like, it's all about power. What connections am I get? How many people can I fire? No, it's about serving, right? How can you better the community? There was a lot about responsibility in this document. That's the spirit of the document. And I think that's really important. So here, and even when it comes to titles in the United States, right? You're always former or whatever you were. Former, always, except for president, who gets to keep honorary. You keep that, but only as an honorific. It doesn't mean anything in terms of the actual title. That's amazing. I don't think people appreciate that enough, so I'm just highlighting that because I think it's the best provision that we can have, and it tells you that we're supposed to be a government of equals, right? Because once you go back, guess what? You're, not that you're nobody, but you're just back to whatever you were, right? So that means that you're rotating between the offices. And so that's particularly important. So creating a system that really is about the people. And that was particularly important because, as Madison says in Federalist 51, you know, if men were angels, then we wouldn't have to worry about this. But once you set up a system that controls the governed, the next thing you have to do is to figure out how to control the government and put things in place that create that balance of power. Because the thing that the framers were worried about most, and this is what I'm most worried about today, is that people don't think about this narrative. The thing the framers were worried about most is the concentration of power in one hand. And that's why this separation of powers, by the way, is unique to us. You know, and I'm going to... The way we've separated powers, that's unique to the US system. It comes directly from, you know, Enlightenment philosophers that have sort of informed this, like John Locke, from this philosophy around the social contract theory, that the government has a contract with the people, and there's an obligation for the government to protect things like life, liberty, and property, coming directly from Locke, in exchange for people not, you know, taking, you know, the no vigilante justice, for example, people abiding by kind of the rules that are set to regulate society within the government. But what that means, importantly, is that there's a limit to government. There's a purpose of government. It's not just you can do whatever you want because you're in power. That you have a goal. Your goal is to protect the community. And when you're encroaching on that goal by having concentrating power, for example, and then overreaching, you're violating that contract. You're violating your obligation to the people, and that's really important. And so the reason, you know, Locke suggested we separate out the functions of government into these three branches is so that the power won't be concentrated in any one of those branches. And that's really, really important. So when we see any kind of governmental overreach by any of the branches, right, but we're seeing it particularly with the executive, but when we see it in any of the branches, we should be worried. And we're seeing it a little bit with the court, I mean, in our interpretation of judicial review, but we should be worried because the whole point is that there's actually supposed to be a checks and balances here. You know, the other thing that's important when it comes to the spirit of the document, you know, was written from the perspective of the accused. If you think about the framers, for example, right? They were rebels. Their opinions were not welcome, right? They were challenging power. They were challenging monarchy. And they were being punished for it, often tried without having notice of the charges against them, right? The things that they corrected for, all of those grievances we see in the Declaration of Independence, those grievances were answered in the Constitution. Right? So 4th, 5th, 6th, 8th Amendments, we call them collectively constitutional criminal procedure. That's not for the state. Not that we don't want the state to do its job of solving crime, but those amendments are there from the perspective of the accused to make sure someone's not wrongfully accused. There's, in other words, a healthy skepticism of government, right? Search and seizure. You can't search someone's house unless there's probable cause, unless you have a warrant. Due process. You can't deprive someone of liberty unless you give them an opportunity to be heard, right? So we want to make sure we set up a system where people are being treated fairly, and again, with a healthy skepticism of government. That's patriotic. So when people are saying, oh, you're out there with the No Kings protest, you hate the government. No, peacefully protesting to say something is wrong, let's do this, that's patriotism, that's patriotic, because that is that's what's enshrined, in fact, in the First Amendment, in the Constitution. So same thing here, separation of powers. And what we're seeing now, here are some of the challenges I wanted to bring in as we're just talking about these things, some of the contemporary challenges. So the reason these things are contemporary challenges, initially we saw these funding freezes, right, that had come in, and this is now a separation of powers problem between the executive and the legislative branch. And the reason that's a problem is because even though we have a lot of executive agencies, like these agencies here are all under the control of the executive, but these agencies have been created by Congress. Remember, it's the legislative branch that kind of has the power to establish agencies, so it's not really within the executive's purview, for example, to fire only one party from the boards of these agencies, right? That's actually an unconstitutional challenge to their power. The power is just to oversee in good faith, right? The Article 2 requires that you're overseeing in good faith the execution of the laws, but not to just override the balance of power that was created by Congress. And the funding freezes in particular were problematic because, again, that allocation was allocated by Congress. And so when Congress allocates something and then initially the executive steps in and says, well, I'm rescinding that, it's not clear you have the power to rescind that because that has to come from Congress. Now, if Congress writes a bill to say that, that's different. You can then again, now we take that back to the policy level. Then you can say, oh, I don't like the bill. Oh, you cut too much. You shouldn't have done it. That's different than when Congress allocates the money and the executive is like, oh, no, I'm not going to distribute that. Or the executive comes and puts conditions on the money. That's what was happening too, right? Conditions on the money, which, by the way, they can do, right? Executives are able, they're able to come and put some conditions. But the problem with some of the conditions in the last couple of months is that they were completely unrelated to the statute. So you can't come in and put conditions on money that's coming from a statute that has nothing to do with the implementation of the statute. That was the constitutional problem. So that's just not, oh, one party is complaining about the other party. That's an actual constitutional violation. And so we have to be careful about that. So that had been coming up. The other thing is this division of power between Article 1, Section 8 and the 10th Amendment. So I want to just take a minute, since we have copies of the Constitution, take a look at Article 1, Section 8. Article 1, Section 8. I don't know if there are page numbers on here, but what do you see in Article 1? So Article 1, again, is the power of the legislative branch, but it's the federal legislative branch, right? It's so federal Congress. And that's when we say the power of government, because that's the lawmaking power. And so the entire scope of power of the federal government is listed in Article 1, Section 8, period. Meaning if it's not in Article 1, Section 8, the federal government does not have the power to act. And there are only two clauses in here that allow an expansion of power. One is the Commerce Clause, and the other is what we call the Elastic Clause, which says we can do things that are necessary and proper to execute the laws that are enumerated in Article 1, Section 8. But that's it. Everything else is listed in Article 1, Section 8. So what do you see there? What are some of the powers of the federal government? And then we'll talk about why would the framers have been so specific about these powers.
Borrowing money.
Borrowing money, great.
Regulate commerce with foreign nations,
Yep.
the states, and Indian tribes.
Great. So that's the one clause that actually has led to the expansion of federal power over time. But there's a reason that commerce, especially interstate commerce, right? Commerce across the United States is regulated by the federal government, plus money, plus taxes. So you have a lot of monetary functions there. Great. What else do we see? Yeah.
Coin money?
Yes.
This meme coin that's getting...
Right. Yeah. Yeah, what kind of money is being coined, right, and whether or not money has to be actually backed by the actual security, right? And yes, with the digital currency, that's a new thing. It's also who's profiting from the way the digital currency is being created. That's the bigger problem too, right? Going back to and going back to the clause that I like the most, no titles. There's also no emoluments. Like you can't be again. You're not supposed to profit at all from being in office. And has that been happening? And whenever that happens at all, we should be looking into that. So yes, but that power is with Congress, and the reason for that is because before we have the Constitution, anyone know what document we had? I just almost said it. Articles of Confederation. So we have the Articles of Confederation. The problem with the Articles of Confederation is too much autonomy to the states. Because remember, our default is to give autonomy to the states, but it turns out if you want to be a united federation of states, you can't have that much autonomy. Like if every state, for example, is coining money for itself, that's going to be a problem because every time you travel, right, there's a cost to that. There's a transaction cost. If every state is doing postal service, for example, that's not going to be helpful in creating a united federation. So if everyone remembers back to the creation of the euro, for example, right, it became much easier to go between countries in Europe, and that's what the European Union serves as, that kind of federation. And when the United States is a federation of states, we need a central government to create a federation of states, and that's why the central government is there. So you can see that all the centralized functions of government are in Article 1, Section 8, right? And so that's why the banking power, collecting taxes. What else do you see there? That's really the power of the federal.
War.
Yes, all the war powers, right? Creating a navy, all the war. So that's all in Article 1, Section 8, because that has to be centralized, right? We can't just have states volunteer to contribute to that fund.
To define and punish piracies and felonies.
Yes.
On the high seas and offenses against the law of nations.
Great, exactly. So anything where we're now talking about policies that are going to impact the Federation, especially external facing policies, that's all going to be at the federal level. Great. And
Militia.
to call forth, yes. Yeah, and we can talk about that if they're, right, because the militia and the purpose of the militia has long been sort of defined by federal statutes in particular and separate from a standing army, right? So there's a difference between a standing army and a militia, and we can talk about that. But yes, so again, because you might have to respond, right, nationally to like national disasters, for example, that has to be federal on the federal level too. How about here to establish a uniform rule of naturalization? What is that? Immigration. So we're going to talk about that because that is the power. So it's true. The federal government has the power over immigration. They have the power, for example, over post offices and post roads, right? For the same reason, because it has to be centralized. Well, what about this? To promote the progress of science and useful arts. By securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Copyright and patent, because you don't want to be competing with with somebody who came up with the same idea, right, in another state. So that makes sense that we have a centralized function for copyright, patents, bankruptcies, right? So there are certain things that the framers envisioned ought to belong in Article 1, Section 8, and that's it. And then let's look together at the 10th Amendment. So the 10th Amendment, which we call the Reserve Powers Clause, which says the powers not delegated to the United States. And again, when it says the United States here, it means the federal government. So the powers not delegated to the United States by the Constitution, so that's Article 1, Section 8, nor prohibited by it to the states, are reserved to the states respectively or to the people. So it's interesting that the states and the people get interchanged in the Constitution. But what's important about the 10th Amendment, right, is everything else, every other law that impacts people, housing, contracts, property law, tort law, zoning, everything falls under state jurisdiction, right? The federal government has no jurisdiction there. And that's why I tell my students, these are parallel governments, not one over the other. The only time we have to deal with a conflict is when both governments get to act. So for example, when it comes to fundamental rights that are in the Constitution that also apply to the states, that applies to both. So sometimes we have concurrent jurisdiction, they can both act. Otherwise, we sort of have these powers delineated to the federal government. government. Okay, so I just want people to know that, because we always talk about this as, one over the other when it's parallel. But again, the times of this has really, particularly currently, has become an issue is when it comes to immigration. We have to be very clear, the immigration power is exclusively with the federal government. And the court has visited that a few years back and said the states don't have the power to interfere or to create their own policies around immigration, because that's a centralized power. However, that's still what they're conducting when the federal government is coming in to conduct deportations, for example. Those are still federal investigations. So the state, for example, has no responsibility, because we have separate autonomy, to either help, and we're also not allowed to intervene, right? So you're not allowed to restrict, but you have no obligation to do anything to help a federal investigation. However, we do have we have the Trust Act in Connecticut, where we do in fact send information over to the federal government when there are certain categories of crime that somebody has been convicted of, right? So there are certain contexts within which the state of Connecticut has said, you know what? This person has been convicted and is dangerous, and we will turn that information over. So it's not true that the state isn't working with the federal government. The question is, does the state have to send over information of individuals that are not in those categories, that aren't part of that list, that the federal government is looking for when they're coming to courthouses to interrupt due process proceedings? And the position is no, we don't have to do that, and that's a constitutional right, actually, because it's not part of our state policy, right? That's not somebody we consider dangerous. That's not part of our state practice. Now, we can't interfere, even if the federal government, although I don't know, I might differ a little bit on that, but we can't interfere necessarily with any federal investigation, which we don't. But again, there's no obligation to do any more when the state objects. Now, the conflict is happening the other direction, where you're having federal officers who are conducting federal investigations ignoring state procedures. That's why this whole issue came up about judicial warrants, and the same thing of, do you have to listen to a judicial officer when you're in a courthouse? I mean, can you imagine what would happen if someone else went into the courthouse with a mask on, didn't identify themselves, and they were armed and wound up hurting people? I mean, that would be horrific. And so the idea that the courts can't say, no, you have to provide identification, that becomes a separation of powers problem, and that becomes a federalism problem, because it's really up to the state to be able to say, this is what our protocol is. So we've been seeing those kinds of challenges here. And one of the things to me that isn't maybe a constitutional issue necessarily, although interrupting a due process proceeding is a constitutional violation, but it's also just this sort of sense of fairness. In some cases, the status of individuals has been revoked, right? When it comes to temporary protective status, humanitarian parole, and then you're revoking someone's status and then the next day deporting them. That just feels a little unfair. It's like, well, now you're here and you're undocumented because your status was revoked. And now you're like, well, you have to be deported. So again, that's not actually maybe a constitutional, it just seems like a problem to me of fundamental fairness in that case. Or people are coming back to court because they're required legally to be there. And in that moment, you're saying, oh, you don't have you're not documented, but the proceeding is still happening. And so you've interrupted that proceeding to say, and I'm going to interrupt it at the moment where we tell you to come back to lawfully report, and now you're being detained and deported, right? And so those things I think we have to think about as a society, not only the due process violations, but the sort of the constitutionality of it. The biggest problem, though, is the due process. The biggest constitutional problem, I should say, is the due process of violations, because we have a history of cases, and even this court held the line when it came to due process, and I think that's really important. In fact, the only fundamental right that we have in the Constitution itself is the writ of habeas corpus, which is essentially a due process right, which means you cannot be deprived of your liberty without some ability to be heard, without some ability to see the charges against you, right? Because remember, this was happening regularly to the framers. So that's in the writ of habeas corpus. Plus we have the Fifth Amendment, the 14th Amendment. So we have very well-established protections around due process, Plus, when it comes to, for example, and somebody who's undocumented in the United States who has a claim, who has made a claim that they're likely to be persecuted upon their return to a country of origin, the only mandate in the Refugee Convention that we signed is that we do not return them. That's the principle of what we call non-refoulement, or not returning somebody to a place where they may face persecution. And how do you determine that? You have to have a due process hearing. That's it. And that's very different than the actual due process hearing in civil proceedings, but you have to at least, and I've done them because I was a litigator, that's my background, and I've done some pro bono cases that were asylum cases, and they're very different than other cases, but you have to at least provide that. So when that's being violated, that is a huge, and that's where I say we shouldn't be debating that. That is not a debate. That is not a partisan debate. That is a requirement. That is a constitutional requirement. And in fact, the court said that most recently in the Trump versus JGG case, right? The court said also, the use of the Alien Enemies Act, although they said the Trump administration was able to use the act, which was a little strange too, because it was the act, the conditions of the act weren't met. So what was interesting is the Trump administration said, this is a win for the Trump administration. And then the ACLU said, this is a win for civil liberties, right? And the reason they said that is because the court said, but you can't deport someone unless you give them a due process hearing. You can use the act, but you can't deport them until they have a due process hearing. And by the way, that's basically all that the executive could do anyway. So it was interesting that everybody called that a win. And this is why I say keep your eye on Chief Justice Roberts, because I think that's what he's looking for. I think he sort of lost control of the court after Dobbs in particular. I think he lost control of the court, and he's kind of looking for how do I like walk that middle line where everyone feels like there's a win, because he knows that the court is going to, the history is going to sort of judge him for the work of the court. So I just wanted the due process, and even before what's happening today, we had a series of cases after September 11th where people were being detained as enemy combatants. If everyone remembers, right, everybody was on board. There was huge congressional support, a lot of support in the public for the president to just detain, including American citizens. Sometimes they just got the wrong name of somebody, right? They were detaining them for like 10 years in Guantanamo Bay. And the question was, the congressional authorization was so broad that it said that the executive can detain people indefinitely as long as they've been labeled enemy combatants. The court stepped in and said, no, that's not okay, because whether you're an American citizen or anybody held on U.S. soil, you have to have some process. So the court, I think, interestingly, has always held the line all the way up to the most recent court on due process. But again, that has to be followed, and that hasn't always been the case. Article 2, I just wanted to, there's a take care clause in Article 2 which requires the president to act in the best interest of the public, right? States shouldn't have a target on their back. You can't go after particular party interests. That's actually a violation of constitutional Article 2, of constitutional mandate to act, again, as a fiduciary in good faith. And then some of the challenges today, I mean, we're seeing other challenges. What's interesting to me is how we've seen pushback on these challenges. So there was just recently, we have a long-standing case law on flag burning, which, by the way, I don't like flag burning at all. And I wouldn't, but again, and the court, in fact, Justice Scalia said, if it were up to me, I would put everybody who burned a flag in jail, but I'm not a king. Justice Scalia, I'm not a king, and we have a Constitution. And the Constitution, the right of the Constitution for people to be able to express themselves has to be above my distaste. And that's important. And that's where I think, can you express yourself in other ways? Probably, but that form of expression is protected. So there was just a recent executive order that was looking at criminalizing flag burning. I looked at it carefully. It looks like it doesn't actually do more than, again, restate what the law already is. It just sounds like it's going to. So I know a number of states are now looking at creating their own flag burning provisions, which again is a problem because this was well-established law that this falls within the First Amendment. But I thought the other attacks on the First Amendment were interesting, especially the Jimmy Kimmel. And interesting, I don't really watch Jimmy Kimmel anyway, but I'm not happy about the FCC telling him when to be off the air. But what I thought was interesting is the number of people that sort of stepped up and said, wait, the FCC shouldn't be telling people to get off the air for things they don't like. And that was interesting to me because there is a limit, right? Because we do have a sense that there are some fundamental constitutional rights and they're being violated. The lawsuits against the New York Times and the Wall Street Journal, one of the courts said, come back when you have a cause of action. That's actually embarrassing for a lawyer. You're filing a claim and the court's telling you come back when you actually have a claim. Like that's almost like an ethics violation if you did that. That is an ethics violation if you did it intentionally, right? It could be, I should say. But I mean, that's an embarrassment. That's what the court would say to you. There's not even a claim here that we can take forward, right? And so I think it's interesting the way we've been able to get some responses to some of the things that were happening. And of course, the most problematic is probably the kind of immunity that was given to the executive in the most recent Supreme Court case. And the reason that's particularly problematic is because the framers very explicitly did not give the executive that kind of immunity, even though they gave immunity to members of Congress, other kinds of limited immunity. So we know, based on the congressional record, that they didn't intend for that kind of broad immunity to be given to the executive to specifically avoid having a monarchy, right? Or having, too much power concentrated in one hand with no limit. So government without limits is the problem. And I love this quote from Thomas Paine, that in America, the law is king, right? We have no kings because the law is king. And as an absolute government, the king is law. So in free countries, the law ought to be king and there ought to be no other, right? That's so important, yeah.
So I'm just wondering, since there was this absolute immunity, what's the next step for some kind of reversal?
Yeah, well, great. So the question is, now that we have this, what's the next step for some kind of reversal? And I think the next step is defining the scope of that immunity, because that's part of the problem. Is the court just gave sort of a broad understanding of the immunity applies to official acts of what does that mean? Like, what if you delineate? You could actually delineate that in a way that's more restrictive, and then that would be that. So that would be the thing, probably. That would be the next step. But also, I think it's up to the court. I do think. I mean, I may be alone because I say this and people are like, I don't believe that could ever happen. I do think the way forward, because of the amendment process is so difficult, even though it's there, is to get the court to reverse itself, frankly. And they're not immune from public pressure, despite what anyone thinks. And historically, I can tell you, I've seen the court reverse itself. So, for example, there's a famous Pledge of Allegiance case, and the court reversed itself in 3 years on that case because it was so unpopular that at first they said the schools can require students to, even though it was a violation, there was a religious objection. So it was a First Amendment violation for religious objection. And at first they said, well, that's up to the school because it's so important to build principles of patriotism that we have to let them do what they think is right. In 3 years, they reversed that case because the public thought that was because you were violating the right of free exercise, right? And people were like, what are you talking about? That has to be more important than schools telling students they have to pledge allegiance. And so the court has historically reversed itself. And I think that's the way forward, especially when you see issues. And that's why I say these aren't partisan issues. If you look at electoral reform, for example, gerrymandering, campaign finance, you have high polling across parties in support of those issues. Now, parties aren't moving on it, because once you gerrymander a district, nobody's going to ungerrymander that because you have more power and it's easier, right? It's much easier to have a district when it's gerrymandered. But that's the kind of thing with enough public pressure, the court can step in and revisit that. The court, I don't think we're even using that opportunity enough. So I'll just go to the. This is, where I was. My last two slides were this. What do we do when we're seeing the court acting in a way that we don't think is appropriate or is violating sometimes their own philosophy? We have to act, right? We have to, and that's why your being here is part of that action. It's saying, look, we the people hold government accountable, and that's why I say this. That's why I go whenever somebody wants me to talk about the Constitution. This is the people's document. It's not for lawyers lawyers to decide in law school and the court to interpret. It's for the public to say, this doesn't make any sense, right? The law was always supposed to be written in a way that that it makes sense to people. That's why we have a jury system. And that's why, remarkably, a jury can actually nullify, right, a ruling because the jury can say, this doesn't make any sense. So even if every element of the statute has been met, and this happened in California, for example, when you had the 3 strikes, you're getting a felony of 20 years rule, and you had some kids that were there 3 times they stole a bike, that was a felony. And on the 3rd felony, that was going to be 20 years minimum when you had minimum sentences. The number of juries that nullify that's an act of democracy, right? And that was built into the republic. That's why I say we're a democratic republic. That was built into the Constitution, to the legal system. Why? Because if the law doesn't make sense to people when they're hearing your story, that's not okay. We're not going to hold someone accountable when a jury of your peers says this law doesn't make any sense to me. So that's really unique to the American system. So much of our system is built on this, on this kind of engagement, and there's so much power there. That's why I want to do these talks too. You know, it's less for the information in the talk and more for people to see how much power there is when you come out together in community, you know, and speak up and say, and it does constrain. You know, people say, oh, well, the executive will do whatever they want anyway. No, that's not true. There were times when the executive was constrained, right? And it might seem like a small thing, but it's not, because when you have absolute power, there's no constraints. And anytime you can constrain that kind of power is a big deal. And I think the same thing with the court. You know, it looks like they can just do whatever they want, but no, they're also subject to public pressure. And so the more, and especially Roberts, because, you know, the court, whether you're a conservative or a progressive or anywhere in the middle, the court does not have a good reputation in any law school, in any law program, in any community. That's not good. You know, and my students for the first time are calling justices Democratic and Republican. I mean, you couldn't even tell me who appointed the previous justices. That's an embarrassment to me for the court, that they're identifying a justice by their party affiliation, right? I mean, so that's a problem the court has to deal with. The court has to, you know, grapple with the fact that, like, they're not perceived as a legitimate institution right now. And what can they do about that? But we have to make that clear to them by putting pressure to say, what are you doing? You know, why are you giving this much power? And by the way, this is coming from originalists, right? People who said they're going to interpret the Constitution in a way that aligns with framers' intent. You show me in Article 2 where you found that kind of immunity for the president, even though there's actual explicit testimony that says we're not giving the executive that immunity. We're giving some limited immunity to congressional representatives, but not to the executive. Where did you find that? How could that align with your constitutional philosophy? And I think that's where we have to push back. You know, that's why I want the public, you know, this is not for law students only to discuss. This is for the public to say, that doesn't make sense. You said you were going to go by framers' intent, and that's not anywhere in this document. And so, yeah, so that's why. Yeah, and I'm happy to take questions, because those are my last couple slides, just to say you're a democracy and thank you for being here. So I know I see some questions. But yes, thank you. I hope there was something there then.
Here is, what is the remedy if the federal government inappropriately overrides state government? I think it is the Justice Department, but if the Justice Department becomes politicized by the president firing career professionals and appointing cronies, what can be done?
Yeah, that's a great, yeah. So I want to say I'm a fairly idealistic and optimistic person, but I live in the world. Like, I understand that these are, you know, we have very serious challenges. I'm just hopeful about the power collectively of people to push through those. So I mean, there are a number of things that you can do. Actually, every court, frankly, can make decisions on constitutional issues too, even state courts. So you can even take that up to state courts. But yeah, you will have to have the Attorney General act or have, you know, that will have to be taken to a court to say, you know, if there's a conflict between state and federal power, where does that sort of balance lie in that situation, or what is constitutionally permissible or not, which ultimately, when it goes to the court, right, becomes a kind of decision that binds everybody. And what you see is, not everybody is following the orders of one person, even though we should be worried that the more and more we let that happen, that the more you kind of fire people on a balanced board and say, we can kind of do whatever I want. That's really the problem. But there are still courts, like the courts that have been pushing back to say this looks like it's violating the lines. Even, by the way, there were courts with Trump appointees that have said, no, you can't send the National Guard into Oregon, I think it was, right? You can't send that's not permissible. Like, that's not a permissible use of federalizing the National Guard in that instance. That was a Trump appointee. So, don't forget that people also do their jobs because they're committed to that work. So I think the more we can put pressure on them to follow those ideals, right? Not everybody is bought and paid for. And even people who have the same party affiliation are struggling to figure out, how do I balance this conflict I have of the pressure that I'm getting, but the sense that, like, this just isn't right, and that I think is the role that's the gap we can fill. What can we do to put pressure on those people who are in that, in that space, who committed their life to law, right? And especially these judges, to say, we have to reverse this, or we have to step in, and we are. And the more you see one or two people stepping in, that will have an effect of more and more people stepping in. And I guarantee you will see that a little bit more.
What can be?
It's okay.
It's on, it's just pointed away from you.
What?
Just speak out.
Just speak up, it's fine.
Yeah. What can be done when Congress negates itself and cedes its power to the executive, as is happening now under Republican congressional leadership?
That's a great question. So that's about grassroots elections, right? And kind of getting out there and thinking very strategically about putting pressure on individual representatives, for example, and also trying to prevent these, like, large gerrymandering schemes that are coming up, and you're seeing some pushback, right? Because again, what you're seeing is the public doesn't like it, and that's whether you're in Texas or whether you're in Connecticut. People are like, "What are you doing? Like, we didn't agree that that's the way our government should work." And I think building on that momentum is really important. Now Congress can defer powers to the executive. The court had often stepped in fact, sometimes to say no, and that, by the way, that deferral of power happened under a Democratic president, right? Initially, that's how the federal government expanded, and this is why I say they're both. It's not a party issue, because under a Democratic president, you have this expansion of power, and the court had started to step in when there was a Democratic administration to say, oh wait, now you're going, especially under the Obama administration, right? You're going beyond those powers, and then all of a sudden now it's like, oh no, it's okay, So we have to be careful when the court is doing that too. But again, putting pressure on the districts, and maybe also looking for individuals who are particularly vulnerable when it comes to election strategy, because we have to somehow counter the gerrymandering, right? What's really problematic is all the gerrymandering, because like 86% of congressional, more than that, 92% or something are safe seats. But that's also shifting, because remember, people's interests aren't fixed, and so the more that things are getting hit. So, for example, now the healthcare, the economy, prices are going up. You're going to see people turning on the party in power, regardless of what party that is, and that's also historically true. It's not like these things are static and fixed in time, right? Yes, do we have more polarization? Kind of. I would say that if you go to the Doors, which I've been at the Doors for many years. You will see that even in, for example, from Trumbull, which was a historically Republican-leaning district, now maybe leaning Democratic, though but very purple district, if you talk to people at the Doors, it seems much less polarized than people would think. It's just the narratives that we have are making us seem like we're really far apart. And so the more we can do, the grassroots in-person conversations, or strategically, though, thinking about who do we put pressure on that's going to be able to stand up to your own party, whatever party that is, that's the kind of work that has to be done. And I think that's where collective strategies, that's where the League of Women Voters can come in, not under a party hat, but under, like, who do we put pressure on to get electoral reform through, fair maps, how do we push independent district commissions, how do we push things through that are going to make the system fairer? So work with those organizations and each other.
Can you comment on the current situation where lower courts are making decisions that uphold the Constitution only to be reversed in the shadow court of the Supreme Court?
Great, the shadow docket. The shadow docket, yeah. Yes, the shadow docket is another one that's really interesting. And I think what's interesting about it too is, one, it seems, right, everyone should be uncomfortable with how much the Supreme Court is using the shadow docket. But what I think maybe is interesting about that is that also gives a small window of opportunity where they're testing the waters. Because again, like I said, they've reversed themselves before, and where they're testing the waters to say, like, what's the public response to this? And if it's nothing, we'll just let it go, right? And when it's a lot, they'll realize that that's a problem. But that public pressure takes a lot of work, and that's where organizations like the League of Women Voters become so important, because it's that kind of sustained public pressure that I think will help sort of redirect that. Now, lower courts they do get reversed by higher courts. That's how that's how our system works, because the highest court in jurisdiction binds all lower courts. So there's nothing wrong with that. I mean, that's how the system is designed. What seems to be wrong is when you may think, okay, the lower court is actually looking at the constitutional issue correctly and the higher court isn't. But that's not a systems problem. That may be, well, why is one particular court interpreting this document in a way that again doesn't match framers' intent or originalism, which is their philosophy. And that's where you need to put pressure to say, we need to see the court aligning with actual constitutional values, all the way back to balancing power, right? That's important. So,
is there a mechanism in the Constitution that forces or helps three branches maintain their check and balances with each other?
Yes.
Checks and balances.
Right. So that some of that we talked about, but so the Constitution was designed to have that kind of checks and balances where the court would step in, for example, when when the executive is going beyond the scope of their power in Article 2, or Congress is, for example, deferring too much broad authority, they might step in and restrict that authority. They're just not doing that. And then Congress is supposed to check the executive as well, right? But we always have a problem if you have first Congress and the executive, right? If you have matching parties where you have a dominance there. That's true of either party that's in power. That's where the court is supposed to come in, though, and hold a constitutional line. What I think is interesting, though, is the ACLU's analysis of the Supreme Court term. And what's interesting is there were many, many things that were problematic and things that we should be alarmed by, but there were a number of things where the court held a line, like on due process. And so I do think all hope is not lost, in the sense that we have to continue to push the court to make sure that they're walking that line in a way that actually reflects constitutional values more, and not cave to pressure. And the only way they won't cave to that pressure is to have some kind of counter pressure, right, from the public. And when they see the public responding, they won't go forward necessarily with something they were going to do on a shadow docket. Birthright citizenship, for example, right? It's been firmly established in the Constitution. In Article 14, it says it applies to anybody born, any person born in the United States. And it was very clear that clause in the middle, when it talks about subject to the jurisdiction thereof, was only meant for like diplomats, people who've had children here weren't intending to reside here and have domicile in the United States, or if you're on a sovereign land, like you're on tribal land. So there are very clear, again, these things have been clearly identified. The court has never challenged that, and now all of a sudden it's like, oh, should we revisit that? And the more there's pressure with people saying it's been firmly established, right, that might take them away from going back to that, taking it out of the shadow docket and actually taking it on. Yeah.
What is the definition of in good faith? Is there one understanding of this concept?
Right. Well, we've never seen the challenges like this. Certainly, it's not to be acting in a way that is partisan, right, or is supporting one political party or one interest over another. So I mean, in particular, this executive has said, "I'm going after my political opponents." That I would say that statement itself is a violation of Article 2. You just can't say that, right? You can't go after your political opponents. Whether even, I mean, that's overt. You can't even do it, in a kind of covert way. And but that hasn't been the case before, right? And so there haven't been these parameters have been established in some ways, just like with executive mandates. And now that has happened under both Democratic and Republican administrations, but there haven't really been the kind of parameters that we're going to need to see now, the pardon power, executive mandates, because there was an ethic involved in this that was not to be violated. And I think what we're learning in constitutional law is when you have an informal ethic that kind of drives the whole system, if you don't write down a rule, that becomes a huge problem. Because now all of a sudden it's like you're relying on the ethic, and if someone's like, well, I don't care, well, now we have no rule because we didn't write anything down. And that's exactly what happened with the Supreme Court appointments, right? There was no rule in place. If you only have 1 year left in your presidency, for example, do you appoint the next Supreme Court justice when there's a vacancy in that year? Does the next president appoint? And it was just kind of like a gentleman's agreement, right? Of like, well, if it's within a certain number of months, then it's going to be the next president. If it's within more than a year, it's the current president. But again, if you just decide, I don't care, I'm going to say one way, one time, and whatever's in my interest, that violates that ethic. But we have no rule because the rule wasn't required because there was an ethic. And I think we need to sort of also talk about that. And that's why I say we should not just look at the letter of the document, the spirit of the document, right? There's a spirit of the document that's about limited government. This is both parties understand that, right? The question was just how much centralized power should we have, not how much power do we give, especially to like an executive when our whole history is rejecting monarchy. The executive is the office that the framers were most worried about, the federal executive in particular. So we have to go back to our history. We've seen this game before. It's in the Declaration of Independence. And by the way, July 4th is my birthday, so that day is really important. It was out of the Declaration reading. So we've seen this. It's listed there, and the Constitution answers that. We need to go back to to the origin of why this document is so important, the Constitution.
We keep saying, how does he get away with this? And is he actually getting away with as much as we think he's getting away with? Because it sounds like he announces something, but maybe it...
Exactly. This is where I say there is so much more power in collective action than people think. No, because a lot of, and this is true for, other regimes that are authoritarian. They work on perception of power, and that perception of power and the fear that causes people not to speak up, not to stand out. That actually leads us to think that there's more control than there is. And on top of it, I still think we're different than any other authoritarian state, for example, because we already have a constitution that, by the way, we've all learned in school. So the problem is everybody has kind of internalized these principles. So when you're challenging them this much, it's creating this tension within most people to try and reconcile the things they've learned about balanced government and limited government with the kind of power and what seems like unlimited power of the executive, and that's rubbing people the wrong way, and it's going to continue to do that because we have this document ingrained as a part of our kind of normative framework. And I think that's a really good thing, because whether you want to, because now there's an automatic constraint there, and I think that's more powerful than people realize, that people do have this. Look what happened with Jimmy Kimmel. The Republicans came out and said, what is going, now you're going after the First Amendment, that seems like we shouldn't do that. And what happened was it just kind of reverses course and nobody talks about it again. And now there are 5 other things we have to talk about, right? And so, that's a success. That's why we should really pay attention to times when the public has spoken up, or enough people have said something, and now all of a sudden the executive has changed course. Birthright citizenship was another one, and will they try to bring it up again? Probably. They'll probably try to challenge things again. But remember, every time that you had to change course, that's successful, because it's a strategy to just throw a whole bunch of things out there and have everyone in such a frenzy that nobody knows what to do. I mean, it was my first Senate session, I can tell you, and it was I'm like, what is happening every single week? It was like, okay, we just figured out, you know, especially for education, we just figured out how we're getting money to districts with our surplus, and now it's like this cut is coming down, that cut is coming down, it's like this program is closed. People are reaching out about grants they thought they had, and now they can't implement the program, and I was like, oh my God. So there was so much happening that you can't sort of pay attention, but that's also the problem, you know, is we have to pay attention to when these things are happening, to the most important and the most egregious violations, and just focus on those. And maybe we can't kind of go after every single thing, but go after the most egregious violations with that kind of public, you know, turnout. And that makes I think that makes a huge difference. I think there's a lot of power in that.
If there's no immunity for the president, then why did the Supreme Court give license for the president to claim immunity? You kind of talked about it, but it still like gobsmacks me.
I know. Well, and the real question is, you know, why, given that it's not in the text of Article 2, right? And the framers were so explicit. Like we looked at Article 1, Section 8 together. They wrote down to post offices and post roads. So they were that specific, but they didn't put in immunity in Article 2. And they did, however, even in the congressional record, there was some immunity for congressional representatives. So that does sort of tell you that, you know, we need to think about, well, what is the Supreme Court doing here, and how to push back on the court to say that that's not an originalist philosophy. But again, the scope of that is yet to be defined. So I think like what kind of immunity you have, like what's in the course of your actual official duties. There's a way to kind of, I think, restrict even in that definition. But yeah, I'd like someone to show me where it is in Article 2. I don't know. I'm also surprised that you can go that far from the Constitution as an originalist, right? As a court where you have all of these justices who claim that they're looking at very narrow interpretations of the Constitution. How did you find that? You know, and tell us, and everybody should ask them every time they see them, where is it in Article 2? Show me in Article 2.
That's a good phrase. Where is it in Article 2?
Yeah.
Yeah. So we the people, today we think of this as all of us, but did the framers just think of it as male free landowners?
White, yes.
White free landowners. You added that. Okay.
Yeah.
Please discuss the evaluation of meaning and how we should acknowledge or not what the framers meant.
Yes. I mean, so let me be clear, this is not a perfect document, and the people that wrote it were not perfect themselves. I'm still an admirer of the document because I think there are a lot of principles in the document that are open to interpretation in a way that gets us to the kind of justice that we may be envisioning. So is the right to property, for example, that may be the most contested right, even globally, right, of being able to claim or creating or like perpetuating inequality. You know, some of that comes down to the right to property. So are there things that we need to revisit? Absolutely. But they're also, I think, with having things like the Equal Protection Clause, the Due Process Clause, you know, you have, again, a kind of framework of justice that allows that to also change over time to make sure that those who are not included become, the document eventually includes them, right? And then you also have the mechanisms for advocating for more inclusion, like the First Amendment, the right to petition, the right to protest, right? Like those things are there to try to, and then the fact that the Constitution is open to change and open to interpretation. So those things allow the document to continue to be more inclusive, and it should be contested. Just for me at this moment, this is not a time to contest the document because there's so many infringements on it that I focus on, like what are the principles that we should hold on to that are there, and that's really important, I think, right now. But definitely important to think about, you know. And this is I teach comparative constitutional law too. So this is always a constitutional paradox because the people that draft a constitution are almost always less representative inclusive, and the process is almost always less inclusive than the entire society they represent. And it always becomes a paradox of like, well, then how can you speak for the people when you hardly represented the people when you were there? And this is kind of an ongoing debate in constitutional law. But in a way, if you believe in the document, it's because you take on a position, again, by creating structures that allow that inclusivity to sort of be incorporated at a later time. And I do think that this document does that, though we should also be talking about its limitations. I just don't think now is for me anyway, now is the time to focus on sort of the foundational principles that we need to hold on to before they're dissolved, and fight for them.
And the amendments take action on some of those things about who the framers were and then who we included, right?
Yes, exactly. And that's part of the problem is, especially with a more polarized, especially, and I say polarized not by the people, but by structures, like by gerrymandering, it's harder to get a consensus. So even, for example, the ERA, which kind of technically was ratified because you finally had a state, the final state sign on, but the other states rescinded and it was beyond the deadline, and so it's like, nah, it hasn't been officially certified. But I mean, the fact that we can't even pass an equal rights amendment, right, which is something that I think a lot of people, in fact, agree with, and would get us around all the issues that come up. For example, in Dobbs with substantive due process, you have another avenue to protect women in particular. Even that we can't get certified as an amendment. So that means that the amendment process is too difficult, I think, for it to be. I don't think that's what the framers intended. They didn't want the Constitution to change very often, but now it's almost like it's almost better to go and try to push the court to reverse itself, I think, than to try to push for an amendment. Though I wouldn't close that off either.
Who decides the limit of free speech versus some dangerous speech, threats, etc.?
Yeah, so we have a lot of case law on this, and there are exceptions that have been carved out. And then there are exceptions that people claim we should be thinking about other avenues of speech. So, for example, the exceptions that we've carved out are imminent lawless action. So if your speech is inciting violence or it's inciting imminent lawless action, that's going to be a problem. If it's a threat, that's a problem. If it's obscene, because obscenity is an exception. Hate speech is not an exception. Some people think it is, but it isn't. It's only there's an elevated crime for hate crime, but hate speech is protected. And the court, it's often been debated. We're going to actually debate this in my class tomorrow. But the court has sort of debated, well, where do we draw the line, right? But then I would throw that back to obscenity. It's not clear where you draw the line there either. So these exceptions have gone back and forth in time. And the real important one now, I think, is disinformation, right? And what to do about communications on social media platforms, because those are algorithms that are now closing off a kind of public discourse that was otherwise envisioned by the framers and the philosophers that supported the Constitution. Someone like John Stuart Mill, who said, "Oh, bad ideas are good because we're all going to be in this marketplace of ideas." Well, our marketplaces online look very different because those algorithms are only showing you certain communication. So that means you're not in a marketplace of ideas. You're in like one part of the market, and there's like a whole part of the rest of it that you don't see. So that's a completely different understanding of speech. And so how do we regulate that? Because right now we have First Amendment constraints on regulating it at all, also because they're private providers. So what do we do about this? But yet most people are communicating that way. And this is what's helpful about being a comparative scholar. If we look at Germany, for example, they also have robust protections for the First Amendment. However, they do have more limits on things like propaganda, on things like disinformation. Why? Because of the Constitution being written after and in response to the Holocaust, right? And so you have a way. So it's not like it's impossible to do. What do? We have the First Amendment. Well, they have the First Amendment too, meaning they have a right to freedom of expression, but there are more limits on it than we have. So these are just things that have to be revisited. And again, I think it's important the public revisits it, not just in a classroom and not just in law school, because these are our fundamental rights that we should be discussing and debating, which is why I'm so glad you're here today, to talk about it. So disinformation, that should be someone's project on like, what do we do about it? I'm not sure. My students are working on it too. What do we do at disinformation?
Yeah, huge, and I hadn't thought of it that way.
Yeah.
Algorithm, so thank you. Does the copyright address the government's desire to hide or take away writings of science?
The copyright, like the copyright power?
Does the copy, if you have, who asked the question?
Yeah.
Go ahead, stand, yeah.
So, in terms of a copyright being held as necessary for the promotion of science, and we were talking about.
Yeah.
Does the government then have the right to take away certain publications that promote an idea that may be against a particular ideology?
Oh, that's interesting. Well, so that's interesting because that actually brings the property, the intellectual property right becomes a private right. So it becomes a private right of property. So you would then be depriving somebody of their right of property, which has other mechanisms that have to be in place. So those projects now, government-funded projects, they can probably rescind because they're putting the money into the research and things that are federally funded. But actually the copyrights are protected more because those are individual copyrights and patents.
So in terms of taking away the funding and not allowing that science to be promoted,
Right.
is that not a violation?
It's not a violation of the copyright because it's just, it's of the Constitution.
Where it said the promotion of science and arts.
Yes, so it's not a violation only because it's up to the federal, as long as Congress says is okay. Now, this is where I say, I'm just trying to differentiate policy. I'm not saying it's a good thing. I'm saying it's not a constitutional violation because they can give and they can rescind funding for projects that they don't want to support. The only thing that would be unconstitutional is if, for example, they supported a project that would like violate the Equal Protection Clause, like you're selecting a particular group and you're randomly experimenting on them or something, like that would violate other things. But congressional funding can just be revoked, and this is where the democratic process, is supposed to correct itself because the public is supposed, if you see a policy that's being rescinded like that, for example, and the public is like, wait, what about all these years of data on scientific research? Ideally, that person who's representing that district is the one who has to answer those questions, and that seat can be overturned. Now, the problem with the gerrymandered districts is those seats aren't going anywhere, no matter what you support, even though most of the community that you're representing doesn't agree with that. And that's what happens when you're over-representing certain interests and not others. So the gerrymandering is, I think, the real problems, and we would probably solve a lot if we just addressed electoral reforms. And these are the things that the League of Women Voters, this is why I joined the League of Women Voters, because this is what I care about most, and it's the most bipartisan thing you could possibly tackle. Gerrymandering, campaign finance, term limits, lobbying limits, all of that has huge public support. Doesn't have support of the parties, huge public support. Why? Because it's about fair process. And I think once you create a fair process, you're going to get more moderate policies. Now, that might not be good for everyone because maybe you want more extreme policies, but when you have a fair process, you're going to have a lot more compromise because people's seats will be up. You'll have contested elections, and when you have contested elections, that's a good thing because you have to work to make sure you stay in office, which means you have to build a consensus. So that's where I think I would push just for electoral reform. I think above any other individual policy, a collective bill on electoral reform would get us to a place we want to be when it comes to like free and fair democratic engagement. And it would probably honestly get us to policies many more people would agree on because they're somewhere in the middle where most people are. Yeah, but great.
Maybe you can ask the person, I'm not following that one.
Oh yeah, when the federal judiciary becomes activist, yes, okay. Yes, so and now what's interesting is, right, there was always a claim on the left and the right, though, that people think that Brown versus Board of Education, right? But that's the judicial branch being active on the left. But an activist judiciary, to me, just means you're breaking with your judicial philosophy and intervening in a way that's inconsistent with your judgment. And so, honestly, when it happens on the right, meaning if you're a conservative justice, and you have a commitment to reading the Constitution narrowly, you have now committed yourself to a much more, to a much finer position on these interpretations. So when you stray from that position, that seems very hypocritical. And so that, I would say, is just what's happening now is we're seeing judicial activism there. You honestly, if you read the Constitution more broadly, you have more leeway to actually read it more broadly because you said that's my judicial commitment, right? So I'm telling you that I think the Constitution has to be read broadly. What's happening today is you have these constitutional justices who are strict constructionists, meaning they've made a commitment to read the Constitution narrowly, and they're finding absolute immunity in Article 2. So I'm like, how do you do that? So that is activism. And it's interesting that we don't use that word activism when it's activism on the right, but that's judicial activism because it is breaking with the judicial philosophy for some other purpose. And then you have to fill in what that other purpose is, right? But it's for some other it doesn't align with your philosophy. It's different because sometimes my students are like, oh, I disagree with this judge because I don't like the outcome. Well, that may be different. It depends on, because they interpret the Constitution differently and you don't agree with that. That's not a problem to me. A problem is when you're breaking with your philosophy and it's really hard to find a justification for that. And that's what's and we're seeing that now so explicitly. It's hard to, it's actually hard for me because I have to be very, and I always try to be, nonpartisan in the classroom, and that's why it's good to have majority and dissenting opinions. But I don't want to justify court opinions, honestly, that I don't see, having sort of roots in constitutional law. And I'm always open to students debating, constitutional interpretation. But like now I have to justify court opinions that don't have a basis in constitutional law. So I still present the majority and the dissenting opinion, but I'm struggling with that a little bit because I don't even know how you came up with that, given the judicial philosophy. It's so out in left field that I'm like, how do you come up with this? So it's a good question, and I'm not sure what to do about it. Again, except that I know the court is subject to public pressure, and that's why I say keep your eyes. I mean, I've always said keep your eyes on Justice Roberts. And I think he tried to do this with the Dobbs decision too. Before that decision was leaked, he wanted to create a decision that would have limited the right to abortion but not overturned the right entirely. But he just lost control of the court. And so I think from that point on, it's not clear he can control the court, but you can see his decisions kind of go back and forth where he's like walking the line. He's done it on healthcare. He's done it on a number of things. And I think it's interesting because it's his court and his reputation that we will come, you come back, we look at cases like Dred Scott, for example, Korematsu. These are like stains on legal history. They might have been popular at the time. Nobody cares now. I mean, it's like an embarrassment when you talk about these cases in any law school. And so you're running into a number of cases that's starting to look like that, and there's no justification, there's no precedent, and so that has to be explained to people. And I think he knows that. I mean, this is where I think how do we get them to reverse on that? Is that pressure.
Can I ask a question?
Yeah.
Where is it written that Supreme Court justices have life terms?
Yes, that's a great question. So it's written in Article 3 that they serve in good behavior. I forgot the language. So that has been interpreted to mean they have lifetime appointments. Now, there was a Supreme Court justice that said that doesn't necessarily mean you have to serve a lifetime appointment on the Supreme Court. It could mean, and this was the proposal, a lifetime appointment as a federal judge and a rotating term on the Supreme Court. So 18 years staggered terms was the thing that would, what that would also ensure, because they're staggered, is that every president, I think every other election cycle or something, would be able to appoint a justice, because when you stagger the terms would be up in a way that would be cyclical, so that it wouldn't be this rush to the bottom. Let's get the youngest person we can find with the most extreme ideology we can have, so that they'll stay on the court the longest for life. Yeah. So it's not clear. So the Constitution, the debate has been that the lifetime appointment is required As a federal judge, it's not clear that that has to be on the Supreme Court. And so this is where the proposals for term limits, again, and I judge it by when I see my students like jumping at some, they all love term limits on the Supreme Court especially, because it will help us. It'll also help bring legitimacy to the court, for people to feel like the court's changing. And 18 years is a reasonable term, it's 18 years, that was the proposal. And it was a proposal by a Supreme Court justice, so 18 years staggered terms. So that's something that, again, I think, and I see it among, again, college-age students, huge support for this. So something they almost every time we have projects in class, one or two of the groups talks about term limits in the Supreme Court. So that's how popular it is for them. So they can see what's happening, right? Because they're not bound to like the ideologies, even the Cold War dynamics of what's capitalism and communism, and they're kind of like, what is going on here? Like I feel like I don't have enough money, or I feel like this our system isn't working properly, and so they're willing to see outside of the box, which is why I love working with students. Yeah.
That's a quick question. How can they treat democratic states differently than Republican states when it comes to like fee money?
They can't. I mean,
but are they?
Of course, yeah, they are. Yeah, they are.
Yeah.
Well, at the direction. I mean, you have the president saying, I'm going to go after, or policies that like, oh, this I'm trying to impact, Democratic states more than Republican states. The problem is the policies are so chaotic, honestly, that they're impacting everybody. Like the SNAP benefits, for example, that are going to end, even though there's an opportunity to put in $5 million so that people will not starve, and that's not. Fortunately, in Connecticut, we're able to put some of that in because we have a surplus, but that even the amount that was just put in by the governor, which is the $3 million, that's only going to be good for 2 weeks. You're talking about basic needs. Or if you want to have a debate on other things with the parties, I don't think you should be depriving people of food. So that's the kind of thing that's happening, and that is not executing the laws in a way that's faithfully.
Continue to get away with it.
Right. That's one of the questions. I mean, they're getting away with it in the sense that it's because of all the seats that have been gerrymandered and the people that are more worried about losing their seat. And it's interesting because you see the Republicans that are standing up are the ones who are leaving office, or the ones who are in districts that are difficult. So I mean, this is really more that's like a structural challenge to say, how do we put more pressure on the seats where you have some advantage. And that's going to be the grassroots effort, because the other thing is, people think, okay, we have either a red district or a blue district, and that's going to be safe. But the thing is, when people's interests start being affected, that's not going to be safe for any party, because once you start hitting people's economic interests and healthcare, right, food, healthcare, like prices are going up, people can't afford things. They are going to blame that on the party in power, and so that's not necessarily going to track with, and we'll see, and by the way, local elections are coming up, so I should say the most important thing, right, is every level of government matters, so it's important to have that showing in every level of government, but it will be interesting to see, like a really strong turnout showing that, there's a lot of disapproval will show that, like, this is not okay, these policies are not okay, because I think also what happens, especially at the federal level, is you become, there's like an echo chamber, and people aren't, you're not seeing the impact of the public discontent, and that has to be more visible. So things like the No Kings protest are good, but there has to be constant, more visible objection to what's happening, because I think there are more people than people realize who want to be here and who want to understand what's happening right now, and that wasn't the case, before, and so that's important for people to know, and for them to see, for people in power who are abusing that power to see.
Yes, and then there's two in the back, so go ahead, and then we'll do, I think it was this gentleman and this woman over here. So go ahead.
Who enforces the emoluments clause?
So, I mean, a lot of this, when there's a constitutional violation, it's still to the courts. And the reality is that any court can make a decision. That's why you're having some of these legal decisions where the court is limiting the jurisdiction of the decision for some of the federal courts, so they're not, they're not nationwide applications, because technically in our system, any court can make a decision on the constitutionality. So you can have sort of every federal court saying that's a violation. So it is the courts that have to do that. I know, but some of these violations, like keeping a plane in your personal treasury, it's like obvious. I mean, it's just right. It's so blatant. But that's also what I mean. That's why there's so many people in the room. And I've been doing these talks throughout Connecticut. There's so many people that show up because it's violating just this basic sense of. Also, the sense that you're supposed to serve the office. You're not supposed to profit from the office. We don't need an emoluments clause for people to know that you're not supposed to be there to like serve your own interests. And that's honestly the thing that people like the least, I think, is somebody benefiting from being in office and like serving their own interests. And again, it's just that we have all these structures that we've put in place that are making that difficult to see. But even in gerrymandered districts, when when you're going to hit people at the economic level, those people you're gonna start getting shifts in who you're voting for and how people are voting, and so you have to be careful, right, to make sure that people's interests are actually protected, because there's a lot more power when people come out and show that power from local elections to state elections to federal elections, and there is that momentum there. So I hope to see that at the polls at every level, for every year, because that showing to say we approve or disapprove is so important,
There was a gentleman back here. Go ahead.
Oh, sure. I want to talk some more about immigration and due process.
Yep.
I'm very much opposed to all the deportations that are taking place for various reasons. However, where does it say that, except for dangerous criminals, that I think they should be deported if they've been convicted? However, does it say anywhere in the Constitution about due process rights for undocumented citizens, undocumented individuals?
Yeah, it doesn't say it. So, right, this is, go back to this for that. So the due process requirements, mandates that we have largely come from the Refugee Act that we signed the Refugee Convention, which we made then into a domestic act around refugees. And so the due process requirement there is for anybody who makes a claim. And now somebody asked me, well, there are probably lots of people making a claim of persecution. Okay, that may be true, but anybody who makes a claim of being persecuted in a country of origin, the one mandate that we have, and it's the only mandate, and this is where the only mandate is to provide a hearing. And that's a minimal, and I can tell you because I've done an asylum claim, it's really not the same thing as an actual litigation in a civil court. So that's a very minimal, and then we can take it up to the policy level. And as you're saying, well, I have policy objections beyond the constitutional requirement, and that's why I want to separate the two. The constitutional requirement is that due process requirement. Even that's being violated, though. And it's not really clear, this whole idea of being able to detain people, because one, you're detaining people who have potentially have a credible fear of persecution. It's not a crime. Like, you're not committing a crime when you're here and you're making that claim, right? So you're not differentiating between people too when you're saying, oh, it's a crime for you to be here undocumented. That's not necessarily true. And so all of those things become really problematic. And it hasn't been the case. I mean, there were many deportations, for example, under the Obama administration, but it's the manner of the deportation that's really the problem. And even this, sorry. Even if it's not a constitutional violation, like for what I was saying, it just feels so unethical to change people's status and then to say, well, now we're deporting you. And also, by the way, we have allowed people who are undocumented to serve in the military, and those people have also been deported. It's like, so we should just have a conversation as a society about how unethical that is, to say, well, we can use you for certain things, but now that's not okay. So I think that's where we have to get back to.
Appreciate your answer.
Yeah.
Yes, there was the woman in the far back, and then Lisa will get to you. And then that might be the last.
Next week, there'll be a testing of our voting rights, and in 2 years, there's going to be a challenge to our voting rights. In the area of the parallel federal and state rights, where do the freedoms of the people lie?
Yeah, that's a great question. Okay, so elections are a little complicated because it is up to the states, right? I mean, we went back to like who gets to certify elections. It's the states that certify the elections. And honestly, in a way, thank goodness, because the process is so decentralized, it can't be controlled. And thank goodness that's the case. And most states, too, because we haven't got far enough with technology, that even if you have technology in the voting process, there's still usually some kind of paper backup where we're checking. And we have many checks in Connecticut that you probably know as members of or those who are members of the League of Women Voters. But the problem is now for example, the Voting Rights Act. Why do we have federal preclearance then when actually the electoral power is with the states? It's because there are other violations there. So the Voting Rights Act, right, came out after the 1964 Civil Rights Act, and what you were looking at were like huge sort of interventions in particular states around voter suppression, and that was racially motivated, clearly, right? I mean, that voter suppression had a kind of racial element to it, and so the Voting Rights Act was there. The preclearance is only required in states where that suppression was so obviously a violation of the Equal Protection Clause, and that's why there was now had that been corrected, what the court said is, oh, we're good. It's been corrected. It's been long enough, so I think we're okay. And like in theory, sure, I agree with that too. Like if we have no voter suppression, you absolutely don't need federal preclearance, or you shouldn't have to have federal preclearance because that really should be up to the state then to certify. The problem is the minute they rescinded even a portion of the Voting Rights Act, what we saw was even higher levels of voter suppression than they had initially before the federal preclearance. And so the problem really is you have to correct the problem of voter suppression before you can just take out the federal preclearance. But then it's very legitimate to say, well, then we don't need the federal. After that, after it's actually corrected, you can say we don't need the federal preclearance. So that's the Voting Rights Act. There's federal oversight on a state process for that reason because there are other constitutional violations. Does that answer your question?
Not in the whole.
No, what was the?
Because in the future, there's going to be challenges that we're not aware of yet when we go to the voting booth, and who is responsible for those? Is it the state or is it the federal?
Well, yeah, it's the states. It's the state. The states, right? If there's any, so unless there were other reasons that you had to have the federal preclearance, like anything that happens in Connecticut, Connecticut would be responsible for that. And that's why you have a process. You have a registrar of voters. There's a process in place. You have with the Secretary of State that then has to certify elections and make sure. You have organizations like the League of Women Voters making sure that elections are being run fairly. But that would be the state responsible for that process.
And if the National Guard shows up and they're federal or the state but sent by federal, where does that go?
Yeah. So the National Guard. So there's already federal sort of parameters around when the National Guard can be sent. So for example, even the National Guard being sent to Chicago, they are not allowed to be there to serve in any policing function, right? That's very clear that you can't just send in the National Guard to supplement your police force. And that's really, and it's particularly dangerous if you're trying to send in a standing army into the states, right? Because then you become a kind of police state. And so that's different. So there are certain parameters when a National Guard can come in. Usually it's with the permission of the governor. And then that brings it back to state autonomy, because when the governor says okay, then it's okay. But even then, there are certain purposes that the National Guard can sort of be used to fill, like they can fill certain roles. but they're not really supposed to be there, to help with policing and to help, so even in elections with security, and that's not their role. The role is for relief for emergencies and for disasters, and usually the governor wants the National Guard because the states need more support. That's going back to why we have collective resources and centralized resources. So making sure we're clear on the parameters of the National Guard, and it's really been the governors that have been pushing back to say, nope, well, thank you, but no, we didn't ask for this. Governor Lamont had to say that too, like, he said it more politely. Maybe the other governors were like, thank you, but no. We'll let you know in case we need the National Guard, but we're not asking for the National Guard. And so that is really up to the governor, because the governor is the executive of the state. And again, going back to, the federalism, it's the governor that gets to say when they want the National Guard. In most cases.
Except for martial law, right? Like what happened?
There's
an inappropriate assertion of martial law
right.
in midterm elections.
Right.
But
those
don't have enough time to be tested by the court because it's done last minute during the election.
But the federal courts can, and this is where I say that a Trump appointee basically limited that when it came to Oregon, for example, because the conditions weren't there. So again, you can't just make claims of, okay, well, we're calling in the National Guard because we're seeing, riots, or we're seeing the kind of conditions that would warrant troops to be sent in for like an emergency situation, because even the federal courts can say, I don't see those conditions, and can stop that, which is what they did. So any court, right, you can file it in a court and get an injunction for that to be stopped. And we did, and again, we are seeing courts hold the line. So in a way, we should also be writing op-eds talking about the courts that have been holding the line in the right way, because there are courts that are stepping in, and we shouldn't have to say it's a Trump appointee, because it feels like you should just do it depending on the context. But the fact that you have Trump appointees doing that now too, that's important, and that takes some courage, obviously, because not everyone is standing up for things. So
it's almost better that these challenges are occurring now. It's like the administration is shooting themselves in the foot for the midterm elections because there will be judicial determination.
Because we already have, exactly. And absolutely. And that's the thing. I don't see a strategy here. And maybe, I don't know if I'm missing something, but it's so chaotic. And the other thing is that's not sustainable. That's not a kind of power that I think you can sustain over time, because it's like people are like in a frenzy all the time. And it doesn't matter where you are, in political life. It's just like you have no idea whether or not your child is not going to be working, someone else is not going to be working, someone's job is closed, right? There are all these prices are going up. People can't afford construction because the tariffs are hitting people in different ways, and so that unpredictability, I think, is just unsustainable. And that's what hopefully, though, that's what's important about mobilizing, because showing that is what makes it clear. Like, there's no way to measure the discontent right now, except for these kind of polls here and there. But the way to measure it is actually through elections. That's how you measure how people are feeling right at the moment. Yeah.
And Lisa Kasten, you're going to wrap us up with a question.
Okay. I was just going to make a sentence statement. I just got back from Memphis, where I know the governor welcomed the National Guard, but the mayor was not very happy. So it's just,
Then there's that's tension between the state.
So what's keeping me up at night is what I characterize as murder on the high seas. And it may not be what is keeping people who are looking at their last meal and where that's coming from. So I get that. But it's 57 people were killed so far. And we know that some of the people that survived, some of them in terrible condition, were repatriated, which indicates that they weren't part of drug cartels. And finally, even if they were, this is not terrorist activity. It's for enterprise.
Right.
So how do we, and they should still be entitled to some due process. So how do we push back on some of that?
Absolutely. No, that's a great question. That's hugely problematic. There you have mechanisms of international law too, because you're violating international protocols. And I actually wonder in some way if they're waiting for an international mechanism. In fact, you have an international mechanism where you can hold somebody responsible whether they want to be or not. Like we have an international criminal court that can hold leaders of violence responsible, whether they want to or not. Now, that court has never held somebody in the United States responsible for atrocities because of the power the court, the U.S. kind of holds. But those global dynamics are shifting too, and so that's interesting because there was, for example, this alliance with India. Now with the tariffs, it's not clear where that is. Maybe there's more of an alliance with Japan and Korea, dependent based on this recent trip. But those things, I think, are, given that the uncertainty, especially with this president, those things all shift. So there, I think you can even pull on international mechanisms. But I think, I see a lot of sort of public outrage about that, and I see more discussion about that with in terms of political representatives too, because it's. You're right. You're getting a boat with distress signal. Again, it violates your fundamental principles of humanity, which is, I think, when you get people to say this doesn't make sense. It's a lot because they're doing a lot that's wrong all at one time, and that's why it's important to push back against it. But and I can't say it enough. I do think anything that we can do visibly and take advantage of things, even like op-eds. I don't think people realize enough. And again, in a comparative context, all historical freedom movements for independence, everyone had their own independent press because communication was entirely controlled by the colonial administration. And so you have to be able to get your own message out there. Now it's become harder. Again, that's why I say disinformation is the thing we need to think about. But people still read their local papers. Not all of them are controlled and consolidated. And even those local papers are looking for op-eds to be in them. So I think there are ways that we have to figure out, how can we collectively push our voice forward in a way that's going to be heard. I think getting a strong showing in local elections, right, that's going to show something, because that's not gerrymandered in the same way. So you'll be able to see district by district what that looks like and how people are feeling. And what's very interesting to me is the narratives on the local elections are all connected to the national politics, which almost is never the case. Local elections almost always separate themselves from state and national elections. Not this year, right? Not this time, because too much is going on. And I think that's so. I do think that this is going to be a referendum on the administration, and that's important too. So go out and vote.
Thank you.